now.
Okay, we're on page 11 of the new law update. And under the category of Maine Criminal Justice Academy, Chapter 196 is an act regarding the citizen members and the Complaint Review Committee of the Board of Trustees of the Maine Criminal Justice Academy. And this law defines a citizen member of the board as a citizen, educator, or municipal official appointed to the board by the governor, who is not and has never been a sworn member of a law enforcement agency. The law increases from 3 to 5 members the Complaint Review Committee of the board. 2 of the 5 members must be citizen members of the board, and a majority of the committee members, including at least 1 citizen member, must be present for deliberations. And this involves an enactment of a new part of 2801-A and amends parts of 2805-C. Chapter 255 is an act to expand the disciplinary authority of the Board of Trustees of the Maine Criminal Justice Academy. Currently, the board's only authority in terms of looking at an officer's certification extends only to those situations where an officer has engaged in criminal conduct, regardless of whether the officer was prosecuted, and a couple of other categories of failure to meet mandatory training and non-compliance with the mandatory policies, the provisions of which are set by the board. But essentially, an officer it would only be facing potential decertification if the officer engaged in a criminal act. This law amends that to include that the board adopt rules for standards of conduct that would subject an applicant for a certificate or a certificate holder to disciplinary action for a violation. The amendment authorizes the board to take action against an applicant for a certificate or a certificate holder for violation of the standards of conduct that are established by the board. And any such action taken must be supported by a statement of findings and must be issued as a written decision of the board, both of which are public records under the Freedom of Access Act. And the Academy will be, if it's not already, engaging in rulemaking in order to implement this new law. So again, it establishes standards of conduct, the violation of which would subject an officer or an applicant to disciplinary action by the board. Chapter 256 is an act concerning records of the employment of law enforcement officers and corrections officers. And the application of this new law is for those situations when an officer, law enforcement or corrections, who is currently employed by an agency or who was so employed within 90 days prior to making a new application for employment as a law enforcement officer or corrections officer with a different agency. And the applicant will be required to sign a request that an employing agency release all employment records to a hiring agency. The Board of Trustees at the Academy is required to adopt rules establishing a standard request and waiver form. An employing agency that receives a request must promptly release all employment records to the hiring agency. The agency that releases the information is immune from civil or criminal liability for releasing that information. A hiring agency that receives information must treat the information in the same manner as it treats any other employment records of the employee of the hiring agency. And the hiring agency is immune from civil or criminal liability for receiving the requested information. When a polygraph exam has been performed on a law enforcement or corrections officer and the results indicate probable cause to believe that the officer is or has been involved in criminal activity, the agency that conducted the examination or for whom the examination was performed must release the results of that examination to the head of the agency that employs the officer. And that to some extent occurs now, but this makes it clear that this is a legal requirement, and it enacts two new provisions of Title 25 under the Academy statutes. Page 13, under protection orders, Chapter 432, an act regarding the violation of a protection order. Under existing law, a person who violates a protective order issued by a state of Maine court through conduct that is reckless and that creates a substantial risk of death or serious bodily injury to the person named in the protective order, or who assaults that person, commits a Class C crime. The same conduct that violates a protective order issued by another jurisdiction would only constitute a Class D crime. This change in law provides for the same Class C crime if the violation is of an order that is similar to a protective order and that is issued by a court of the United States or another state, territory, commonwealth, or tribe. So it just brings all those protective orders or violations of those particular protective orders into the same category of it being a Class C crime when violated. Protective custody, Chapter 377 is an act to change the standard for taking a person in protective custody, and it revises the standard for law enforcement to take a person into protective custody. Current law is based on probable cause to believe that a person may be mentally ill and, because of that condition, presents a threat of imminent and substantial physical harm to that person or to another person. This new law changes that standard to probable cause to believe the person is mentally ill, and due to that condition, the person poses a likelihood of serious harm. The likelihood of serious harm is the existence of a substantial risk of physical harm to the person as manifested by recent suicide attempts or threats or serious self-inflicted harm, or a substantial risk of physical harm to other persons as manifested by recent homicidal or violent behavior, or by recent conduct placing others in reasonable fear of serious physical harm, or a reasonable certainty that the person will suffer severe physical or mental harm as manifested by recent behavior, demonstrating an inability to avoid risk or to protect a person adequately from impairment or injury. This is a substantial change to the standard for law enforcement to take a person into protective custody. It actually is a lesser standard than existed before October 18th, in that standard before October 18th required a threat of imminent substantial physical harm to that person or another person. And the imminency is pretty much taken out of that in favor of the three different categories that constitute likelihood of serious harm. And that standard is essentially the same as the standard for blue paper. So prior to October 18th, the standard for protective custody was a bit higher than that for blue paper. And now the standard for taking someone into protective custody is essentially the same as a blue paper. Training was offered recently by Dr. Deb Bader, the state's chief forensic psychologist, and Assistant Attorney General Molly Monahan. And that training was recorded and is available for you or any of your officers to access. A message was distributed on the law enforcement listserv as to how to access that training. And if you have questions about that, you certainly can contact Brian MacMaster in the Attorney General's office, and you will be given access to that. Public Records and Freedom of Access Act, Chapter 153 is an act to increase governmental accountability by removing the restrictions on the dissemination of information regarding investigations. And this law essentially just repeals, it does away with Section 807 of Title 16, which is the so-called Glomar response, which prohibited a criminal justice agency from confirming the existence or non-existence of confidential intelligence and investigative record information to anyone not otherwise eligible by law to receive the information. And again, this is under the section of Title 16 that talks about intelligence and investigative record information, and not necessarily that part of Title 16 that talks about criminal history record information. So again, it repeals section 807. On to page 14, still under freedom of access, chapter 252 is an act to improve information sharing by criminal justice agencies with government agencies responsible for investigating child or adult abuse. And that that law amends the provision of section 806 of Title 16 that delineates exceptions to the confidentiality of intelligence and investigative record information. Again, this is not criminal history record information. That's a different part of Title 16. To clarify that a government entity responsible for licensing or regulating the programs or facilities that provide care to children or incapacitated or dependent adults, essentially child protective and adult protective, are entitled to the information subject to reasonable limitations to protect against those harms that are contemplated and listed in section 804 if the information concerns the investigation of suspected abuse, neglect, or exploitation. The law also enacts a new provision that permits disclosure of information to a government entity responsible for investigating child or adult abuse if the information is being provided in response to a request for records regarding a particular person or persons, and the information relates to alleged or proven conduct that is criminal under the criminal code and those chapters that are listed. And I won't go through each of those chapters. There's about 8 or 9 of them there. Again, it amends part of 806 in Title 16 and enacts a new subsection in 806. Chapter 313 is an act to implement the recommendations of the Right to Know Advisory Committee. This goes to the fees that can be charged for public access to cover the cost of copying public records pursuant to the Freedom of Access Act. And the law sets a reasonable fee to cover the cost of copying at no more than 10 cents per page for the standard 8.5 by 11 inch black and white copy of a record, and provides that a per page copy fee may not be charged for records provided electronically. So that obviously needs some attention in that that fee has been capped at 10 cents per page for an actual hard copy of a record. Chapter 353, an act regarding the review of law enforcement use of deadly force. There's two parts to this law. One, it amends the Intelligence and Investigative Record Information Act in Title 16 to make it clear that the act does not preclude the public dissemination of that portion of a video in the custody of the Attorney General depicting the use of deadly force by law enforcement when the public interest in the evaluation of the use of deadly force by law enforcement and the review and investigation of deadly force by the Attorney General outweighs the harms contemplated in Title 16, Section 804. So essentially, it sets the stage for the Attorney General to decide whether or not the release of video depicting the use of deadly force is so much in the public interest that it outweighs those harms that may be contained in Section 804, such as unwarranted invasion of personal privacy, interfering with an investigation, prejudice to an accused in terms of pretrial publicity, and those are just 3 of the harms listed in 804. But it essentially tells the Attorney General to evaluate that situation and decide whether the public interest outweighs those harms that normally would have been cited in refusing access to the video. And the public interest, just to point out, is in the evaluation of the use of deadly force by law enforcement and the review and investigation of those incidents by the Attorney General. That's what the public interest is. The public interest is in the operations of government and not necessarily just because the public is interested, if that makes any sense. It's very limited to the public interest in evaluating the use of deadly force by law enforcement and the review and investigation of those incidents by the Attorney General. The second part of that law sets up a timeline for completion of the investigations or the release of by the Attorney General of the public of his determination publicly in terms of the justification of the use of force. And it says that the Attorney General is required to complete an investigation of and submit the findings regarding the use of deadly force by an officer to the Deadly Force Review Panel within 180 days of receiving notice of the use of deadly force. So 6 months from the time of the use of deadly force to the time that the Attorney General is required to make a legal determination and then refer that matter to the Deadly Force Review Panel for it to do its job. If that 180 days is exceeded, or it looks like it may be, the Attorney General is required to provide notice to the panel and provide a summary of the investigation up to that date, identify the reason for the delay, and provide an anticipated conclusion date for the investigation and findings, which may not exceed 270 days from receiving notice of the use of deadly force. So there is a provision in there that could extend the announcement of the Attorney General's determination to up to 9 months from the time of the use of deadly force, but with that required reporting to the Deadly Force Review Panel. And again, this law took effect on October 18th and will apply to all deadly force investigations from that point forward. Page 15, an act to implement the recommendations of the Right to Know Advisory Committee concerning fees charged for responding to public access requests. And again, we go to the fee schedule that's within the freedom of access request. And the law extends the time period for which an agency or official may not charge a fee for searching, retrieving, compiling a requested public record. And it extends that from the first hour of staff time to the first 2 hours of staff time. So in other words, the first 2 hours of staff time taken up by processing a freedom of access request is free. You can't charge for it. Where before it was 1 hour, now it's up to 2 hours. However, the per hour fee has been increased from $15 to $25 an hour. Break.